Hello, welcome back everyone, and thank you for staying on with us. Before we start, I would like to make a quick announcement that unfortunately Mr. Kudun Sukhumananda is unable to join us today due to some personal urgent matter. So without further ado, allow me to welcome the moderating speaker, Kun Panithida. She is the associate with Kudun and Partners. Let's welcome her on board.
Thank you, Linda. Good afternoon, everybody. Welcome to the ALB Virtual Thailand In-House Legal Summit on the ultimate roadmap set in the right itinerary for Thailand's Pdpa compliance journey. Pdpa has been heavily discussed not just among the lawmakers, but also among the business operator in every industry, because the Pdpa aims to give back control to the data subjects. And because of that, it urges all business operators to rethink about how they will handle the personal data from now on. From our own experience, Pdpa is a lengthy process and requires collaborations from all departments of your companies that have any contact with the personal data. From the due diligence, the data mapping, the gap analysis, the implementation, and of course, the training. It normally takes at least 4 to 6 months for the whole process. Before we start, we wish to thank the participants who have taken your time to provide your response to our survey before the session. From your answers to our survey's questions, almost all of you have started Pdpa compliance process and have asked us a very interesting question based on the actual problems that you face through the session. So we have structured the seminar in a way that will help you solve those problems. Kun Kongkoch, our partner, and Kun Nattaya, our senior associate, will join us in the panel today.
Good afternoon, everyone. It's my pleasure to be here today.
Good afternoon, and thank you for all of the questions that you have given us earlier. It is our intention to help you with your concerns. So we have shaped this seminar as a Q&A session, and I believe you can send your questions to us through the chat box here, so we can answer them at the end of the session. You're welcome to ask any questions that you may have. So from the questions that we have gathered earlier, let us start with the question of what are the main obstacles business operators face when doing Pdpa compliance? Kun Kongkoch, can you help us answer this question?
Sure, I will take this first question.
Kun Kongkoch, could you speak up, please?
Sure. It's good. It's better. Okay. I will take the first question here. I think I would say that generally, in order for the company to comply with the Pdpa, you need 3 components to work well together. And those components are people, and the other 2 would be documentation and the system. For me, I think among those components, I think people is the most challenging one that you need to handle with. This is simply because setting up the documentation and also the system for me is like a one-time job. When you work at it and it properly comply with the Pdpa, you don't need to do it any longer. Of course, except when the law change and you need to comply more additional legal requirements, or you may sometimes need to reflect the dynamics of your business activities. But that's something that you not have to do it pretty frequently. This is different from the other elements, the people, you know. It's not like documentation or the system. The system and documentation is something that when it's done. But you must not forget that Pdpa is not a set and forget job. It's just not like you do it and it's done already. But during the period that you run your business, you have to keep all the functions, all the 3 elements in place and work well together. That is why I think that people is more challenging, because during that long period, you know, when you have a good documentation and a good system in place, the people, your employee, your staff who handle the personal data or have personal data in their possession, they have to know in very practical level or operational level in terms of what to do or even what not to do when they handle the personal data throughout the information life cycle. Also, there are special feature of the people that make the situation more difficult to handle because it's not like the system or the documentation that is there for you. The employee keep changing, the new one will come in, also the old one would eventually leave you. So, but it's difficult because it's your job to ensure that all of them, old ones or new ones, they must know what they need to know in order to comply with the PDPA. Also, that's all just set aside all the human errors, ignorance or negligence, which of course you would be aware that it happens all the time. And for those reasons, I think the most challenging part for the PDPA compliance are people, and it's something that you need, I think, need your special attention. Yes.
Okay, that's very interesting, the people part. So how do you think that should be done, training the people?
Well, I think that's something that you can do. First of all, I think the company should have a manual, a written manual that set all the requirements, all policy, all practices, the good practices that assign clearly about their responsibilities for employee in order for them to read, understand, so that they understand the function, in respect of the work that they do on a daily basis in order to comply with the PDPA. Also, don't forget that when you prepare the employment agreement for them to sign, you need to set one clause in the agreement that those policies and practices form part of the agreement. And also there should be disciplinary consequences if those employees fail to comply with them. That one thing, I think, from the written policy or manual, they can read and understand them. But the next thing would be you need some training as well, because for them to fully understand their function in order to comply with the PDPA at the operational level, you need to train them and also provide a regular follow-up audits. That thing, I think it's very essential. The main objective of the training is to raise their awareness about the company responsibilities and also liabilities under the PDPA. Also, you will let them know how their roles can help the company to achieve that goals and compliance. How and when to use simply documentation and the system that you already have in place, right? This include, as a practical matter, how to deal with your customer or customer complaints in order to avoid unnecessary dispute. This can maintain your good reputation and also manage the good relationship with your client or customer. Okay. In reality, I think dealing with the customer and their complaint is very important. I can give you some example. It can be, I think, once the PDA effective meets next year, I think you can all imagine that most of the time, when the regulator comes to your door, it is because they receive some complaint from your customer. It's just not like they do a regular audit, but it mostly comes from your customer. This can be compared with the complaint that the customer submitting to the Office of the Customer Protection Board, which is the law that are already applicable right now. And if you have the chance to read all that complaint, you will see that most of the time issue in that complaint is very minor or petty. And I can assume that you would think that didn't those customers have something better to do? Why did they want to waste their time like that? But in fact, if you look into the details of that issue, you will find that those issues have been raised to the company many times, but because the company didn't get or give any meaningful response to the customer. That's why they go to the regulator instead to get some attention. That would be, I think that would be a situation that you can find when the PDPA apply next year as well. All right. The next thing that I think you need to do in your company is also assign someone or a group of people, if you can, to be responsible and accountable for data protection compliance of the company. From our experiences, the company should have one people from IT personnel who can directly manage the company's data security, and also one from legal department who can give you an advice in terms of how to comply with the PDPA from legal perspective. And the simple function of the committee is mainly to be the go-to group of people when there are personal data issue arise, or to conduct the in-house training that I mentioned before. Okay. One thing that I want to mention, and you shouldn't forget, is that at the end of the day, if there is any issue arise, the regulator may require the company to show your accountability for PDPA compliance. So in that case, the company needs to write down or put in writing the policy and practices so that you can show them that you already in place the manual for the your employee to comply. In addition, you may have some additional evidence, such as training record or disciplinary action. This kind of thing can support that the company already have everything done possible to prevent any privacy breaches from happening. All right. Okay. All this, I think you can get a clear picture that or conclusion that humans are the weakest link in your organizations. Lots of time when you have everything done that I mentioned, but all it takes is just one ignorant or careless employee that can ruin all the work or the good work that you have done. They simply you can imagine they usually lost username or password or even laptop, and that simple incident can eventually to see an issue. So this is something that I think I would like you to keep in mind. Just don't overlook or underestimate the PDPA or data security issue that can be caused by your own people. Yeah.
I think that's a brilliant perspective from the human resource part. I would also like to add about the systems that a company may use as supporting tools to the PDPA compliance. There are several tools that a company can use to facilitate PDPA compliance. For example, consent management system and data subjects right management system, where they can help automate the process, validate the identity of the data subjects, and keep all relevant records in order to be PDPA compliant. And how will these systems help your company? For example, for consent, the company must keep track of all the consent they have received from the data subjects. Therefore, when a data subject asks to withdraw any consent, the company must know which personal data they will need to stop processing at that very moment and where that data is incorporated in the company in order to delete all of it. The data subjects right management system will work in a similar way. Also, you may have to work closely with your IT department when it comes to breach notification. The goal is that the company must be notified when there's a breach of personal data, because the company is under the reporting obligation both to the government and in certain cases with high risk to the data. The company will have reporting obligation to the data subjects themselves. Now, our audience have given us some questions beforehand. Now let's move on to another obstacle that one of the audiences is facing right now, which is what legal basis to apply with what activities, especially the legitimate interest basis. For business operators, the legal basis most used will be contract, consent, legal obligation, and legitimate interest. From our experience, our clients are curious the most about how to use legitimate interest basis. Well, I would say that the legitimate interest is the most flexible lawful basis, but it's not always be appropriate to use. Key takeaway today is that your company may only use this lawful basis only when the processing fulfills these three-part tests, which is shown on the screen right now. The three-part test consists of the purpose test, the necessity test, and the balancing test. The purpose test means that the company must identify its or any third party's legitimate interest to process personal data. So what can be a legitimate interest? It can be commercial interest concerning an individual, or any interest in a broader sense. To help you get a clearer picture of what legitimate interest can be, now that Thailand does not have any cases yet, but we tend to follow what happens to the application of the GDPR. So I think we can also learn from the cases under the GDPR. There's this case happening in the Netherlands where the court confirmed that legitimate interests could cover a range of different interests, provided that they are real and present, i.e. not speculative, meaning that all kinds of factual, economic, idealistic interests can qualify as legitimate interests. The second one is the necessity test. It means that the company must identify the necessity of such processing if there is any other way which is less intrusive that the company can do to achieve the same goal. It will not be deemed to be necessary. So you may ask yourself this question: is there another less intrusive way to achieve the same goal? The last test is the balancing test. It means that your company must balance your interests against the data subject's interests. Also, the data subject must be able to expect that their data will be processed in this way, meaning the processing cannot be beyond their expectation. Examples of legitimate interests are when an employer asks to collect basic details of the candidate's spouse, or the use of CCTV for prevention of or investigation of crime.
Great, thank you. I understand that what you've been discussing so far is about the processing of the general personal data. Are there any special concerns when the company processes sensitive data?
Oh, right. I think sensitive data is something that you need to treat it with extra security under the PDPA. This is simply because it could lead to, discriminatory treatment to the data subjects. So how we handle the process of security sensitive data is not the same as the general one. For example, collection cannot be based on the contract or legitimate interest that Kunaja just mentioned. In addition, only in some limited circumstances that allow us to collect the sensitive data based on legal obligation basis. Okay, so the key point I think I want you to focus and keep in mind is that in some cases, just obtaining consent to collect sensitive data may not be sufficient. Um, just example, I have two cases with me for you to learn about how sensitive data should be treated in special care. They happen under GDPR, but I think in the future it should be taken to account when it happens in Thailand as well. Both cases are about use of biometric data, which is sensitive data. The first case happened in Sweden. This is about the school case. This school use the students' face recognition for their, attendance management, and they get consent for that process. But we can learn from the court ruling that number one, the court said that the consent should be given freely. And in this case, unfortunately, the court see that the consent could not be considered voluntary because of inequality in power between the student and the school. And also a data protection impact assessment, or DPIA, for this sensitive data was not made properly because it lacked the assessment on proportionality and assessment of the risk and that exists for the data subject rights and freedoms. Okay. Another thing that the court says that registering attendance in class may be made in less intrusive ways, meaning that the use of facial recognition was disproportionate to the purpose. All right. That's the first case that happened already in Sweden. The second one is happened in Poland. It's also happened in school as well. But in this school, they instead of facial recognition, they use the fingerprint recognition to identify their student, their children. And again, the school get consent for the data processing in this case as well. But the court still rule that it's breach of GDPR because the school may perform the identification by other means that do not interfere so much in the child privacy. So I think this case can apply. We need to consider it when we considering to comply with the sensitive data in Thailand under PDPA. All right. When processing in Thailand, it's likely that when you want to process the biometric data or sensitive data, discussion among the lawmakers suggests that DPIA must be made, and in that process, the control must assess the necessity and proportionality of the processing of sensitive data. That for the sensitive data.
Thank you. That is very useful information. But those are GDPR cases. Do we have to be concerned about what happens outside Thailand? Are there any chance that we could be subject to the GDPR as well?
Well, this is one of our audience's concerns because they told us that they are also subject to the GDPR. Well, I would say that it is also possible for a company in Thailand to also be subject to the GDPR if it's offers good or services to data subjects in the EU. But it doesn't mean that if you're based in Thailand and you're selling goods online and there's a person in the EU buying your goods, that you would automatically be subject to the GDPR. The key word here is targeting. Only when you target the sale of goods or services to people located in the EU will you be subject to the GDPR. Examples to this can be that if you are having a website and you have this website translated in France and the payment can be made in euro, this can be one of the things that they would consider that you could target to sell goods to people in the EU. The second thing is that will make you subject to the GDPR is when you monitor data subjects' behavior as far as such behaviors takes place in the EU. Well, monitoring in this case means that the controller, meaning your company, has a specific purpose in mind as to what to do with such data. For example, behavioral analysis or profiling. And you would want to do something with such data later. So what will happen if you're doing any of the above activities? Well, the answer is that your company will be obligated to appoint a representative, a natural person, or it can be a company in one of the EU member states where the data subjects are. Well, but not all companies doing such activities will be subject to the obligation to appoint a representative under the GDPR. Exemptions will apply to the processing that is occasional, that does not include large scale of processing of sensitive data. Well, the GDPR doesn't define what large scale means. That is the hard part. Or the processing which is unlikely to result in a high risk to the rights and freedom of the data subjects. Well, if you're subject to the GDPR, what you must also think about is the language you will use to communicate with data subjects outside Thailand. Next slide, please. I bet everybody knows TikTok. Well, this case happened in the Netherlands. Well, TikTok doesn't have any headquarters in the Netherlands, but a lot of their users are children in the Netherlands. TikTok was fined for 750,000 euros for not having its privacy notice available in Dutch, which is the main language used in the Netherlands, which is okay. Dutch is the language used in the Netherlands where their data subjects are located. Since so many of TikTok users are children, it was decided eventually that TikTok is violating privacy of young children in the Netherlands. Well, key takeaway from the TikTok case is that business operators must know your data subjects and risks associating to them, and try your best to communicate with them in a transparent way regarding their privacy. In the TikTok case, data subjects include young children. Content that these young children share can be seen by anyone and shared to anyone. Therefore, children may be subject to online bullying or be manipulated in any other way. All of these aspects, for example, the risks associated with the processing and the number of data subjects concerned, will all be taken into consideration when calculating the fine. So you have to be careful.
All right. Thank you. I see that several companies in our audience today are multinational corporations. So what would be the main concern for this type of the corporations?
For multinational corporations, the main concern would be cross-border transfer of personal data. Okay, you can see in the slide that a company in Thailand can send personal data to a third country if any of the following circumstances occur here on the left-hand side. If those countries are listed on the whitelist, FYI, Thailand does not have the whitelist as of today, or any of the derogations are met, one of which is when a consent from the data subject is given, where the data subject has been informed of the inadequate level of data protection of such third country. Or in the third case, in case of cross-border transfer within group companies, cross-border transfer can also be made when there are binding corporate rules, or as we know as BCRs, are in place. But these BCRs must first be approved by the Office of the Personal Data Protection Committee. Well, in the absence of all those, the whitelist or the BCRs, the controller may transfer personal data to a third country only when enforceable rights and effective legal remedies for data subjects are available. Such safeguards may be provided for by standard data protection clauses in contracts, or what we normally know this as the SCCs, which basically ensures that data subjects can still enforce their rights after their data has been transferred overseas.
All right, that is very helpful. Now, since we've been helping quite a lot of clients with the PDPA compliance, could we share our clients frequently asked questions and how we provide the solutions to them? The first question is, if a company has a privacy policy and a privacy notice, is it enough to say that such company is PDPA compliant?
Well, the answer is no. To be PDPA compliant, all aspects of the PDPA shall be applied. Having a privacy notice is only one of them. Key takeaway are that a company shall ensure that it follows the following principles and measures. First thing is lawfulness, fairness, and transparency. Well, lawfulness means that you must always apply a legal basis to all of it, or any legal basis to all of its activities. This ensures lawfulness. Fairness means that the company handles personal data in ways that can be expected or can explain why any unexpected processing is justified. Well, transparency can be ensured by the company providing privacy notice, which is written clearly. Well, the next principle is purpose limitation. It basically means that the company must only use personal data for the purposes that the data subjects have already been notified. The next one is very important, and a lot of people, they're not aware of this principle. This principle is data minimization, meaning that the company can no longer collect any personal data which does not serve any of the company's purposes. Well, common mistake that I saw is when a company hires their employees, and in the job application, the company asks to know the application's religion. Well, I'm not saying that that is absolutely wrong, but what your company must rethink is whether such information is necessary for the recruitment process. If the answer is no, your company cannot ask for that data, even though you got their consent. What is similar example is when a school asks their students, we have a lot of clients who are schools, when a school asks their students what their religions are in order to prepare proper meals for them. And well, in this case, we help the school to comply with the PDPA by interviewing the school about the purposes of collecting the students' religions. Well, the answer that the school gave us is that it's only used this data for meal preparation and nothing else. Our advice to the school is that the school should only ask for data about food preferences as to what the students cannot eat. Well, asking for religion just to serve this purpose is not proportionate to its purpose, and it could lead to a breach of this data minimization principle, which could lead to an administrative fine. Accuracy, next slide please. It basically means that the company must ensure that personal data they collect is not incorrect or misleading. Storage limitation, meaning that the company can only retain personal data for as long as it is necessary to. And this one is one of the most important ones is the security measures. The company must ensure that it puts in place security to the level that corresponds with relevant risks. Security measures must ensure confidentiality, integrity, and availability of personal data it processes.
All right, thank you. And the next question will be, can we still use CCTV? And what should we do in order to lawfully use CCTV?
Okay, I will take this one. The answer is yes, you still can use the CCTV, but there is additional step that you have to take. That is, you need to notify the data subject, meaning any person who enter the CCTV area. So you need to notify them that you will collect or process their personal data, which is their images and behaviors. So in terms of PDPA, you have to notify them before or at least at the time that you collect the data. So what you have to is that you need to put the sign, the notification that state the information that PDPA requires, including the types of personal data that you will be processed, the purpose for the data collection, and also their rights, the data subject's right toward the such processing. And as a good practice, I would recommend that you may consider have a very noticeable, a very clear sign with the information required by the PDPA. And in order to make it noticeable, you may consider put a lot of signs during in the area that you have the CCTV on. Also, we have some cases in Spain that may show or guide us in order to operate the CCTV. Number one, data collected to the CCTV must be minimized. The camera directed to the public, have to capture the passerby without any justification is unlawful. So you need to limit your use of CCTV. In addition, data subject must be sufficiently informed of the existence of the TTV, as I mentioned. So that's something that you need to do in addition to comply with the PDPA. Yes.
Thank you. And I would say that this is the most frequently asked question that we have received so far. And we've got this question from the floor as well. Can we still collect a copy of ID card, which might contain sensitive data when making contract or for billing access?
Yes, our audience is in the live session has asked this question. Well, the question basically is whether we can collect some sensitive data on the ID card. Well, the answer lies in the basic principle of data minimization that I just mentioned and the lawfulness ones. It means that the controller cannot process any personal data that is unnecessary to any of its purposes or has no legal basis for the processing, or else it may face civil claims, which can include class action, criminal charges, or administrative fines.
Right. Then what happens when you have to collect a copy of ID card which may contain like sensitive data such as blood type or religion?
We suggest that the company ask the data subject to cross out any unnecessary information prior to providing it to the controller for collection.
Right. And what about the collection of the ID card before for the building access?
Building access.
Yes.
If crossing out certain information from the ID card is not possible at that very moment, because when you access a building, it may be fast and collecting everything can slow you down. The company must rethink the way it controls building access. For example, giving access card to the data subjects in exchange for their names and phone number and any other information if necessary. Well, however, if the company thinks that it is necessary to collect the whole ID card, consent must be given prior to or at the time of collection. For example, consent can be given via electronic means by having the data subjects showing their ID cards directly in front of the camera as an affirmative action that they have given you the consent. Also, at the same time, the data subjects must also be notified of the information required by the Pdpa.
All right. So since we are running out of time, now I believe that the audience might have some questions. So let's move on to the Q&A session.
Okay.
Okay.
One of our audiences asked about how will they know that the objective that their use or their application of legitimate interest is objective and fair. I would recommend that you do the balancing test. It means that everything that you do, if you collect a data using legitimate interest basis, you will have to keep in mind that the data subjects must be able to expect that you will process their personal data in this way. And I would suggest that you do a DPIA in this case, so that you know all the risk associated to this processing and you know how to mitigate the risk. Well, the next question is about a company which is MNCs, located in a lot of countries. Their website, they welcome applicants from Thailand as well, and they ask whether their website must be translated in Thai. Well, I would say that transparency is key, but the answer in this case is it depends. If one of the qualifications that you ask for in an applicant is that they must be fluent or perfect in English, Thai translation of privacy notice or Thai translation of the website may not be necessary. But if it's not required that their English must be very good, then at least the privacy notice must be translated in Thai in order to achieve the transparency principle. Okay. A lot of the questions concern transfer of data. If we are a company in Thailand and we transfer personal data to our branch outside Thailand, will this be considered cross-border transfer? Well, the answer lies in the draft regulation. The answer is no. Only transfer of data from an entity to another entity will be considered cross-border transfer. Transfer of, well, if your company is in Thailand and you transfer some kind of personal data to a branch in another country, this will not be deemed cross-border transfer. Is our time up now? Okay.
All right.
I
So
think
next,
there is another questions about COVID-19.
right. All right. Can a company collect a temperatures for data subjects for COVID-19 screening?
Okay. I do hope that we don't need to do a temperature check for so long, but the answer is yes, we can, because collection of temperature, even though it's expensive data, because it's a health data, but the consent, we don't need it in this case, because the collection of this kind of data concerning dangerous contagious disease for public health purpose, and the company would have a legal obligation to do so for public health interest. This is an exempt from the required consent. You can see that the company will be required under the Communicable Disease Act to report to the relevant office if there is any COVID cases or a COVID case is suspect in such a building. But to keep in mind that the company, you must notify the data subject of the information related to the collection. That is the purpose of the collection and the identity of the company.
Another question from the audience is that what can we do if we believe that the government officer sell our personal data? Well, I would say that only certain government offices is exempt from PDPA compliance, but they still be subject to the security measure. If you are, I would conclude that if you are data subjects, you can always exercise your rights under the PDPA, even though your counterparty is the government. Well, next question is, if my company is using cloud, will it automatically be considered that we are transferring personal data outside Thailand? Well, if the cloud server is located outside Thailand, then it is international transfer. But only two exceptions will apply in this case. The first one is when you're using cloud for transit or storage purposes only, meaning that no access from outside of Thailand is allowed. Then this will be exempt from the cross-border transfer under Section 28 of the PDPA. But one thing to note here, that whenever you're using cloud, it means that you have engaged a processor, and a DPA must be made between you, the controller, and the processor. But what happens if you're using Google Cloud? Will you be able to ask Google to sign a DPA with you? The answer may be no, and it would be very hard. What the solution to this is that you look with the terms and conditions that Google provide. That I believe Google have complied with the GDPR, and having signed the terms and condition or having agreed to Google's term and condition would be safe enough, and it can be a substitute to the DPA. Well, this next question is, we got asked this question a lot. Can we do cold calls from now on? Yes, you can do cold calls, but there are a few processes you must do before you do cold calls. I would assume that you do cold calls to sell goods or services, because that's the problematic thing that we have faced today. But consent may be needed in this case. What we would suggest that you do is that you get consent from the data subject through the person who gives you the personal data, and the privacy notice shall also be notified to the data subject through the person that gives you the data.
All right, thank you. This has been a very useful session. Kudun and partner would like to thank the audience and Kun Kongkoch and Kun Nattaya for joining us today. We'll welcome any further question that you may have. Feel free to contact our lawyers, which they contact shown on the screen. We'll be more than happy to help you through the PDPA compliance journey. Thank you.
Thank you very
Thank
much,
you.
everybody.
Thank you.
Thank you.